Retirement is often seen as a destination, but we believe it's an opportunity to pursue your passions, realize your dreams, and live a purposeful life. Great decisions, incredible lives. Retire with Intention podcast is about more than just money. It's about embracing the things that truly matter, the experiences, the relationships, and the impact you leave behind. Here is your host, John Creekmur.
Well, everybody, welcome back to Great Decisions, Incredible Lives. And I'll tell you what, I am so pumped again this week to be introducing you to a new friend of mine, Kendra, and phenomenal background, eager for her to tell her story and also walk through ways that you can make some wise decisions in a couple areas of life. And as you guys know, every single week we just drop all these different interviews, and you guys have met some incredible people, and I've got a huge docket coming down over the next couple of months of some new interviews that I'm really excited about. So make sure you check in every single week, and you get the podcast alerts every single time. Remember, whatever channel you want to listen to, our podcast is on every single channel out there. And so thank you so much for the support and the feedback you're giving to us, even about different shows and topics you want to cover. And actually, Kendra really fits in with a lot of feedback we have been getting as far as information people need about a very significant area of their life, and that is on their planning, their estate planning. And Kendra, attorney licensed in the state of Colorado, phenomenal background. Everybody, make sure you check out the show notes with some great links over to Kendra, her website, ways to connect with her. And I know you guys are going to be blown away and really blessed by the things she's walking through today. Hey, Kendra, before we get started today, can you walk through, introduce yourself, give a brief background, and then we'll kind of hop into things.
Absolutely, John. Thank you so much for having me on this podcast. I've listened to a couple of episodes and I've just been really looking forward to this. So, as you mentioned, I am a Colorado attorney and mom. I'm a Colorado native, so all of my schooling was here in Colorado. I actually set out to be an attorney, from the time I was a little girl. It was what I knew I was going to be. Didn't know exactly what the role was going to be, but I always just told everybody I was going to be an attorney. Originally, I thought I would be a DA for Arapahoe County over here in Aurora, Colorado. And throughout my law school career, I got to have some incredible experiences. Ended up graduating and being a personal injury litigation attorney. I had some fantastic mentors. I worked for a great law firm here in Colorado, and it was fantastic. But ultimately, litigation can be a lot of work and it can be draining. And I realized that my strengths were so much more on the client side and helping the clients, being with the clients, and not fighting the court system, fighting my opposing counsel who, might have had happy hour with the week before. So I transitioned from personal injury litigation and founded my own law firm, Strong Law, with a focus on estate planning.
It's kind of funny you say that, Kendra, about wanting to be an attorney ever since you were a little girl. And, I can imagine, were you like argumentative in the family? It's like, your mom would say, hey, Kendra, go ahead and do this. And you're like, well, let me present 3 points, Mom, as far as why I shouldn't do that.
I definitely negotiated. Yes. My mom will tell you that I'm her favorite, but yes, I definitely negotiated, and I was maybe a little bit stubborn and set in my ways for sure.
Yeah. That's a lot of fun. I always tell people too that I was the only kid in the 6th grade that read the Wall Street Journal every day. So I do think there's certain things in life that we do that set us up, and we have a certain skill set and passion for things. And it's great that you have found yours, and you've made this transition from the courtroom, really, as far as litigation, onto a different area over the last couple of years. Kind of walk us through the area that you really focus on as far as in speciality, and then maybe what kind of brought you into that decision to go a different way as far as in law.
Absolutely, John. Yeah, there's a lot behind that. So my law firm, we focus on foundational estate planning. We help our clients to get the essential documents in place that are going to help them and their families accomplish their ultimate goal. How we get there and what documents we use vary based on the family dynamics, based on the assets they have, and again, what their goals might be. So I set this up, and I set up my processes in such a way, and I always tell my clients, my goal here is to keep you out of court and out of conflict. And we do that because, again, I was in the courtroom. I've experienced that. We have experienced going through the probate process with my own family. And, it's going to be different for everybody what probate is. In our situation, it's been dragging on for 2 years. It's cost us several thousands of dollars. And we actually hired another attorney who specializes in probate to help walk us through that. Despite the fact that I could have taken it on, that's not my specialty and I wanted to stay within my lane. So absolutely, that's kind of my transition was a big blessing to my family. I wanted to be more present, more at home, get out of the courtroom arena, and just be really able to focus on the foundational planning.
Yeah, now you had mentioned this key phrase, but I think it's critical. I love the way you said that. Out of court and out of conflict. And so those are two big phrases, quite honestly. Can you kind of unpack that a little bit before we hop into foundational? Can you kind of hop into like what does that mean be out of court and also out of conflict? Is that conflict like in life in general? Is that in family? What does that mean?
Yeah, absolutely. Happy to break that down. Court and conflict. So we all know that when people pass away, that tends to create a lot of conflict and some discord within family, right?
Mm,
Sometimes people are not happy with the inheritance that they're left behind, or there might be disparities. Or if you're in a blended family situation, you can unintentionally disinherit children,
mm,
and that may not be what you want during your lifetime. And so when we're talking about keeping your family out of court and conflict, the court aspect of it means litigation, having to go through probate. A lot of my clients choose not to go through the probate process. In Colorado, it's fairly easy. It's an administrative process that somebody has to go through when you pass away if you die with a certain amount of wealth, right? A
mm,
certain dollar amount that's dictated by Colorado. And so when people go through probate, it's time consuming, it's costly. You can do it yourself, but most people actually hire attorneys that are going to help walk them through that process.
mm,
Then the conflict side, right? I don't want your loved ones to have to fight. I don't want them to have to duke it out in court. And so we really help to put protections in place in the documents that we're coming up with. And we also have really meaningful conversations. That's where the counselor part of me being an attorney comes into play. And I tell all of my clients, I'm going to ask you very personal questions about your loved ones, about your family members. I want to know who they are, how they operate. Are they good with money? Do they get along with their sisters and brothers? Because if they don't, we can create some clauses that ultimately, when you pass away, then your loved ones are fighting, and that's not what you wanted.
mm, mhm, mhm. That's interesting. I've had so many interviews over the last 30 some years with people on this exact topic, and they always say, hey, our kids, they all get along. That's not going to be an issue for us. Have you seen things kind of work the other way of some people that assume that things are going to go well and there's not going to be any conflict, and all of a sudden when mom and dad are gone, it kind of goes the other way?
Oh, absolutely. Absolutely. It happens all the time. You like to think that we have the closest, best relationship as siblings, and
Yeah.
you
Yeah.
never fought a day during your life, but ultimately things happen. And we're all humans, not saying that it's going to be perfect. It
Mhm.
when a loved one dies, you're dealing with so much grief. There's the emotional aspect of it, and then divvying out the responsibilities and who's in charge and being able to, just dictate all of those things. Naturally, conflict and some things can come up. So
Mhm.
yeah, we've seen some big fights. One of the bigger cases that I worked on was, three siblings. They at various stages of their life were in communication, or one of the sisters hadn't talked to the other one in 20 years, but now all of a sudden they had to come together and agree on things in
Yeah.
this probate matter. And it was going on for 3 years because the sisters were fighting amongst themselves.
Hmm.
So yeah, we absolutely see that happen.
Yeah, it's interesting too, because a lot of times it involves money, but a lot of times there's more to it than just the money. There's the relational aspect, there's the things that have happened in the past, and so I think by having things worked out well and working with someone like yourself that asks those questions that sometimes are a little bit nosy, but they're professionally nosy, right? They're asked to get to the heart of what it is you're wanting to accomplish, and I think it's critical to make sure that the foundational things are taken care of, because when they are taken care of, well, then you can actually build upon that as far as the next generation. So speaking of the word foundation, you talked about financial planning documents, a financial planning strategy, and your process. Can you help unpack for everybody what is foundational as far as in this entire topic? Well, what all does that involve?
Yeah. There are some core documents that I consider foundational that everybody over the age of 18 needs to consider. The first one will be a financial power of attorney. So giving somebody the authority to help manage your financial affairs on your behalf. A medical power of attorney, that's who can make medical decisions for you if you can't, right? Those incapacity situations. And then you're also going to need some sort of document that handles your assets upon your passing, whether that's a will, or a lot of the documents that we draft here are revocable living trusts. So that's a foundational document. Guardianship nomination, if you have minor children, is absolutely critical as well. So those are that's like the core 5 that I make sure that my clients have.
Yep. And then you kind of build on it from there. Now, you had mentioned something earlier, that an unintentional disinheritance of your children. And so that concept is just fascinating to me, that someone would disinherit their children, but do it not knowingly. And so all of a sudden we walk through these core documents. Can you give some examples or talk about what does that mean to unintentionally disinherit? And then how does that process you just mentioned, and the tools that you mentioned, the documents, how does all that work together to make sure that doesn't happen?
Absolutely. That's a fantastic question, and it's very near and dear to my heart. I work with a lot of blended families. We're just in a stage that marriage does not look the same for everybody in every single family. And the law, unfortunately, is stuck with sort of that solo, you have one marriage and you've got 2 kids from that marriage, and it's a beautiful thing, and you live forever, you live out your lifetime, and then you pass away and those 2 kids inherit. But unfortunately, that's not the way that most families look in America anymore, my own included. And so a perfect example would be if my husband and he had 2 kids prior to us getting married, and now we have a son together. So altogether, we've got 3 beautiful children. But if my husband were to pass away first, the law says that I get everything as his spouse. And so what could happen is that if he passes away first, I could end up not leaving money for his children if we don't take careful consideration into planning. And with those delicate conversations around how do we make it fair for everybody, and what does that look like? And so that's where my specialty really lies, in helping to navigate how are we going to provide for each scenario and each situation, because we don't want to disinherit somebody unless you want to.
Right.
Which you can,
And
right?
do
So
it
within the
intentionally, right?
documents, you want to be very careful with it, because that can lead to conflict and lead to court if somebody's very unhappy with that. But yeah, so we utilize the documents. We utilize, a revocable living trust in this situation to make sure that money and assets are protected, or outright gifts are given to the older children so that they don't feel slighted.
Mm-hmm. So is there a certain type of trust you would use for that would help as far as with preserve those assets just for the children?
Yeah, so we, within the revocable living trust, you can build in other trusts as well. And sometimes I refer to them as asset protection type trusts. So, and gosh, there's so many variations. You'll hear other attorneys call it a marital trust or a family trust. And what it ultimately means is just at the passing of the first spouse, a percentage goes into another sort of trust, like 50% of the decedent's estate goes into a trust that is now irrevocable. And it can be used by the surviving spouse, but within certain parameters, and it can't be changed or given away to anybody else other than what was dictated by the decedent.
Okay. Now, I'll tell you what, Kendra, you are touching on so many points of things I've heard from clients over the years that which they have a lot of confusion. So let's simplify things here. So you had mentioned a medical financial power of attorney and medical power of attorney. In case you cannot make those decisions for yourself, there's someone that you've authorized to be your power to go ahead and make those decisions for you. Then we have a will, and then you mentioned a revocable living trust or an irrevocable living trust. And then underneath those are kind of the core documents, right? And then underneath that revocable, irrevocable, there may be a whole bunch of other trusts that have got similar names or different names that kind of build upon the revocable, irrevocable. Is that pretty much summarized right?
Correct. Yeah. I always end up drawing out Venn diagrams for my clients when they're here, because I'm a visual person and I want them to
Right.
see what it looks like as well.
Yeah. So then all of a sudden, then you meet with somebody, you go through these questions, you draw out your Venn diagram, they've got total and utter clarity, and they know exactly what they're doing and why. And then all of a sudden, then they say, great, we draft the documents. are they done at that point, or do they have to like somehow change the title of their assets into the names of the trust, or what's that next step for people?
Yeah, next step after signing your documents, if you've set up a trust, attorneys will call it funding your
Mhm.
trust. And sometimes clients are really confused by that terminology as well. They think they have to go open up this trust account and put everything in there. And that's not completely what it looks like. We retitle real estate property. If you own real estate in your individual name, depending on the strategy, more likely than not, we're going to retitle it into the name of your trust.
Mhm.
Beneficiary designations based on the sort of account that you have and what your guidelines are, your distribution guidelines within the trust look like. Your attorney may recommend, if you're a married couple, your spouse is typically the primary beneficiary on things. Secondary would be the trust, right? So
Hmm.
that's kind of generalized information. It's not, I want you to listen to your attorney and they will tell you how you should fund your trust.
Okay. So one question I get a lot that plays right into this is for a lot of people, their two largest assets are their home and then maybe their retirement plan at work, their 401k or some variation of the 401k, depending on what industry they're in. So as long as they have a qualified asset, or their IRA is huge. And so how do they work through as far as with their, let's just say those qualified dollars? Can they put that into the trust or does that become a taxable event? Or would they have the beneficiary or secondary beneficiary be a trust? Any thoughts on the qualified assets?
Yeah, with the qualified assets, so you definitely want to be very, very careful. And estate planners are going to take different approaches. We all try to be very collaborative and approach it. And there's experts and CLEs that we go to make sure that we're giving the most up-to-date information. With the Secure Act, if you are married, we want your spouse to be the primary beneficiary. And then secondary, we would name the trust because the trust is really what controls all those distributions. If you don't have the trust listed, and whoever you've got named individually as your primary or as your contingent secondary, that's going to go outright to them, regardless of what your estate plan says. And so it's very important that your beneficiary designations align with the estate planning documents that you put in place. Because most people, and some people don't realize this, is those contractual accounts, like the retirement accounts, investment accounts,
Mhm.
what you put on your beneficiary designation controls. And that's really important because that can undo an estate plan as well.
Yeah. So I've always had the belief that, or I guess I've held to the principle that the beneficiary designation is a contractual obligation, whereas if someone has a will, that's basically a directive. So in other words, they list something as a beneficiary, that's going to end up trumping whatever's listed unless they come and have a trust listed as a beneficiary. Is that correct?
It absolutely is correct. And that's one of those areas, right? Keeping with the theme of keeping your family out of court and conflict.
Yeah.
If you don't update those beneficiary designations and it's not in alignment, absolutely. Somebody could pull that into court and say, no, that wasn't their intention. And here's the contract and here's the will. And how are they going to fix that? Right.
Yeah. Yeah. Now, one of the things that near and dear to your heart was really as far as with overall on families, and we have a lot of families, husband, wife, or some type of committed couple together, and then they have children, that next generation. And I oftentimes hear a lot and not quite certain what the proper answer is, but someone is wanting to set up a trust for their minor children. Is that something which is a good practice to walk through and have assets in there? And what would be the purpose of having a trust for a minor child?
Absolutely, John. With minor children, that's sort of one of those check boxes of why we're going to lean towards a revocable living trust. And here's why, right? We're going to walk the client through the importance of that. A minor child cannot inherit money.
Mm,
They can't own property, ideally, right?
mm,
And so what would happen is if the two parents were to pass away before their children reach the age of majority, that money is going to be held for that minor child with required reporting and all of that fun stuff that goes along with that. The judge is going to appoint who's in control of that money and who's in charge of taking care of them. It may not be the legal guardian that they're assigned to. And so what we do is we put the assets into a trust that are held in the trust that the parents created with those guidelines. They have the trustee that they've decided. The parents have now put their wishes and their intent in the trust. If they don't do that, then when that child becomes age of majority, and sometimes it could be 18 or 21, just depends on where you're living, then the child gets that money outright. And that could be a significant lump sum that you're handing over to an 18-year-old, and they could just go wild and spend it however they want.
Yeah, yeah. I think that we all think the best of our children or grandchildren at different points of time. And yet I know if I had a large amount of money at 18, 19, 20 years of age, I probably would not have made the wisest decision with that money. And so having the trust and structuring it properly is really, really important. And Kendra, I've seen some trust actually set up for minor children. And once they can receive the assets, there's a certain age that's placed on that, 25. I've been some that distribute assets at for a longer period of time. So maybe a first dollar amount to help them through school or whatever to get started early in life, and then 25 a certain amount, 30 amount, 40 amount, and it goes all the way up like into their 60s. What do you see as a reasonable structure as far as on distribution of assets from a minor child's trust?
Great question. I love to tell my clients that a trust can be what they want it to be. So you can create, just like you listed there, right? There's so many different variations of how you can give your children the money. On average, what I see most people do is the ages and stages, like you talked about. So ages and stages, and that can be traditionally where I see people falling is right, giving money in their 20s. So somewhere around 25, like you said, graduating from high school, college, whatever that might look like. And then another lump sum at age 30 and then 35. Most of the time I see 3 distributions, because after that point, it almost becomes tedious to keep the trust ongoing if it's not really, depending on how much money is in there and what might be. And then on the flip side, so it's really kind of split down the middle of ages and stages. And then we have another tool in our tool belt called a lifetime asset protection trust. And this is a trust that we could actually set up for your children, especially if you're worried about their misuse or judgments, lawsuits, creditors, future divorces. You put this money into an irrevocable trust for them. They're not the trustees on this trust, somebody else is, and that continues for their lifetime. Absolutely.
Yeah. So we've talked about children and even adult children, kind of walking through how do we keep everything out of court and also out of conflict. And I have to think a large part of that has to play into education and communication as far as with the estate plan and how it all works together, and even financial education of heirs. What are your thoughts, or what have you seen that works well as far as when do you start educating, let's say, that next generation as far as how they fit into the plans? And what does that communication look like?
I love doing family meetings. So for me and my clients, that communication looks like, first, we talk to the clients and we help give them talking points to have with their loved ones, with their beneficiaries, with the people that they've named in their plan. And then if they choose and they want to, we can all come together collaboratively and have a conversation with me as the attorney, so then they can understand the terminology and understand their roles and what it means and what they need to do when their loved one or when their parent passes away.
Great. And I think that's something we've had a lot of discussions internally and with some just key clients of our firm, that they're really wanting to have those family meetings because they want to work with a trusted counselor that has the ability to communicate facts and legal structure, but do it in a way that has some wisdom involved in it. So Kendra, I love the whole thought of having those family meetings. I think it's critical for everyone to kind of walk through that as appropriate, but make sure you have a strong counselor that's able to sit there and communicate well your wishes and how things go. We have a lot of people that bring together estate planning, but they integrate that with things that are near and dear to them. And so it could end up being something they walk through in life that they give to charitably. Maybe it's something with faith of which they give to charitably. How do you position charitable planning along as far as with their estate planning?
Yeah, it really comes down to what the clients want and what their intentions are. And within my own intake form, I ask the clients, do you have organizations or, things and places that are near and dear to your heart that you want to receive some of your money? And sometimes that's a resounding yes, especially if they are needing to take advantage of some of the gift taxes and, all of the advantages that come along with that. But yeah, ultimately it just comes down to the clients and what's near and dear to their heart. And just the other day I had somebody doesn't have a lot of money, but wanted to give $1,000 outright to a humane society. And that little bit, right? That means a lot to her, no matter what the value is.
Yeah, well said. One of the things people have asked a lot on here recently is, whenever I have digital assets or I have currency that's not the same as what we normally see historically, does that fit the same way into my estate plan as all other financial assets, or is there certain considerations I should be thinking about?
There are considerations, yes. Cryptocurrency, Bitcoin, all of those, hot keywords that have been coming apart or coming around lately, those have some special considerations. Sometimes you can't name your trust as the beneficiary, but the way that we approach those here at my office is they do allow you to, most of those companies allow you to name a beneficiary. And
Mhm.
if that's the case, then you might have to name either your spouse or maybe your oldest child to receive that. Because what I have found is some of those companies only allow you to name one beneficiary, and some of them don't even allow you to name a trust. And
Hmm.
that, again, when we go back to, well, why did John Sr. get this money from this account? Well, unfortunately, we didn't get the opportunity to edit that as much as we would have. So there are some special considerations that need to be taken into effect there. And sometimes I will refer them back to a certified financial planner to have that discussion and find out if that's the best place for that asset.
It's so interesting because even on my personal accounts, being an early on investor in a lot of different cryptocurrencies, to see how that they've appreciated so much, I was blown away with the fact that with my custodial account, I could not name a trust as a beneficiary. And it's kind of like, man, that's a large portion, right? It's a large piece in net worth, and that's got to be probatable. There's got to be a better solution on that. And so it's a
We're
huge
waiting
thing.
for it, right? It's
Yeah.
still new. It's one of those areas where the law has not caught up, and
Yeah.
we've got to figure out a way because it absolutely is. It can be scary for a lot of people.
A lot of people. Speaking of the ways the law's not caught up, what do you see? Do you see any emerging trends out there in estate planning, things that are kind of happening? Or are we looking at the same way to do estate planning we were 500 years ago? Or are things changing in the way in which we do estate planning?
Yeah, definitely. I think some things are changing and each state is different. So they're going to have their own set of probate rules and trust rules and what codes they're following. There's also a federal code, like there's the universal sort of thing that most states will tend to follow. But that's what's so funny is that each state can follow their own thing. And in Colorado, like we are trying to catch up and they do provide for some blended family situations now. Still not exactly, most people don't want what the default is, but they
Sure.
are starting to recognize, having children from other situations or non-traditional families where maybe you're a committed partnership, right, but you're not
Mhm.
actually married. Colorado, we still recognize common law. So
Mhm.
yeah, there's absolutely some areas that are evolving and changing, and then other areas where you would think you're back in the 1800s.
Yeah, yeah, it's interesting. So, Kendra, I think that's so critical to make sure you're working with somebody that does a quality job in communication, that fully understands the law, but also is fully aware of things as they're changing. Because sometimes they change slowly, and other times, man, they change so quickly. And I think for a lot of folks, even to recognize that their digital assets may be outside of their preference in their estate plan, just because it's not caught up with the way things should be. So it's critical to work with someone. Hey, thank you so much also for talking about just those foundational elements. I think those are critical for people to understand those financial documents to have in play. As we're wrapping up, Kendra, is there anything specifically that we've not talked about that you want to say, hey, I think this is a good piece of info that I want to leave with everybody today?
Yeah, I think, and it just piggybacks off of what you were just saying. The law is going to change.
Yeah.
Your life is going to change. Your assets are going to change. And you need to be able to work with professionals, with an estate planning attorney, with a financial advisor who is going to be able to help you with those changes. And part of that is, does your attorney, does your law firm offer reviews? What does that look like when I come in 3 years later and I've got a new kid or a new marital situation? Or, hey, now I'm a real estate investor and I've got 5 houses. How do I protect these assets?
Mhm.
That is so important to develop a relationship with your estate planner so that you can approach them and you can have those conversations and then find out how you're going to be charged for that, right? Hourly bill, like flat fee. It's so important. And that's why I always recommend, estate planning. It's not a one and done thing. You've got to
Yeah.
revisit it. It changes.
Yeah, yeah, great wisdom. Kendra, thank you so much for the time today. That was so 30 minutes chock full of just huge actionable items. Thank you for spending time with us. Really appreciate it.
Thank you for having me. I appreciate it, John.
Yeah. Everybody, thank you for listening in. We'll catch you next week right here on Great Decisions, Incredible Lives. Until then, make sure you follow up on the podcast and definitely check out the show notes for Kendra's information. Talk to y'all later. Bye-bye.
Thank you again for listening to the Great Decisions, Incredible Lives, Retire with Intention podcast with host John Creekmur. Follow us on social media, visit our website, and join our community of like-minded individuals redefining retirement and living incredible lives. Please leave us a review and share our podcast with others who may benefit. We wish you a future filled with purpose, fulfillment, and the joy of living your incredible life in retirement.